I'd like to thank everyone for joining us today for our Woodland Wildlife Wednesday webinar presented by the University of Maryland Extension Woodland Stewardship Education Program. My name is Andrew Kling, along with Agnes Kedmenez from the University of Maryland Extension. And
Hello.
Today we have two presenters, Jonathan Kays and Paul Garringer, who are going to be speaking about landowner liability and recreation access in Maryland. And before we get to them, we have a little bit of housekeeping to talk about first. Firstly, I need to let you know that this webinar is being recorded. These recordings are used for a couple of different purposes. One, in case you have to leave the presentation, you want to be able to see the entire recording. And we also make it available for people who didn't register through Eventbrite. We make it available on our YouTube channel as well as our website at extension.umd.edu/woodland. And one of the advantages of having registered for the webinar through Eventbrite is you'll get an email from me letting you know when the recording is available and how to access it. There are also a couple of other benefits as well. One is you'll get notices of upcoming webinars and face-to-face workshops when we can get back to doing that, as well as a subscription to our quarterly newsletter called Branching Out. And the next issue of that is due out in August. If you discover that you're getting too many emails from us, you want to cut back a little bit, you're already on a listserv with us for some other reason, and you want to opt out, go ahead and do that by sending Pam Thomas an email. Opt out by emailing her at pthomas@umd.edu with the message, no events. And I also want to let you know that if you have a question or a comment for the presenters during the hour, the easiest way to get our attention is by using the chat box. Down at the bottom of your screen, you'll see a black border with a number of options, and one of them says chat. If you tap on that, it'll open a separate pane where you can type in your comment. And if all goes as planned, we will have time at the end of the presentations to go over those questions, and we'll make sure that the presenters leave their contact information up for a little bit in case you want to write it down. And if you discover that you have a question that comes up later on, you can always email us later on, and my contact information will be at the end of the presentation, and we'll be happy to get back to you as soon as we can. Now, as I said, we have two presenters today, Jonathan Kays and Paul Garringer, and I'd like to tell you a little bit about both of them. Jonathan Kays is an extension forester with the University of Maryland Extension with 30 years of experience in teaching, research, and technical assistance. He's located at the Western Maryland Research and Education Center near Hagerstown, and along with his team manages the university's Woodland Stewardship Education Program, the people who are bringing you the program today. He has developed and implemented extension programs in woodland stewardship, woodland steward training, notably the Maryland Woodland Stewards Program, invasive species management, wildlife damage management, natural resource income opportunities, handheld GPS, disturbed land restoration using biosolids and hybrid poplar trees, and wood biomass energy production. He's one of the primary authors of the Woods in Your Backyard Guide, which was first published in 2006 and revised in 2015. Jonathan has authored numerous extension publications and is responsible for producing the Branching Out newsletter that I mentioned earlier. Paul is a senior faculty specialist and the extension legal specialist at the University of Maryland. Now, I'm going to read the bio exactly as he sent it to me, so any tongue-in-cheek language is his and his alone. He grew up on his family's wheat and cattle operation in western Oklahoma, and upon graduating from high school, he attended Oklahoma State University and graduated with a Bachelor of Science in Agricultural Economics. After graduating from OSU, Paul, for some strange reasons still unknown to him, decided to attend law school and graduated with a Juris Doctorate from some school in Norman, Oklahoma, also known as the University of Oklahoma. After law school, Paul received an LLM in agricultural law and a Master of Science in Agricultural Economics from the University of Arkansas and is licensed to practice in Oklahoma. Paul is an active member of the American Agricultural Law Association, Agricultural Law section of the Maryland State Bar Association, and Southern Agricultural Economics Association, and a member of the Agricultural and Applied Economics Association. So with all that said, I'm going to ask Jonathan to get ready to share his screen. You ready to go, Jonathan?
I'm ready to go. Yeah, welcome. My name is Jonathan Case. It's great to be here. I'm going to talk a little bit. Paul and I are going to kind of go off each other a little bit here, but my purpose here is to provide some background information on landowner liability and recreational access, which I think is important to a lot of people, a better understanding of how that works. A lot of what I'm going to be talking about is included in this extension bulletin 357, which is available on our website at extension.umd.edu/woodland. And because there's a lot of content there, I'm going to be hopping across a number of different topics, and there's more detail in that publication that I think would help you. And also listed here is the AgRisk blog and webpage that Paul maintains. He has a lot of great information on ag law things. He may mention that as well. And he has some specific blogs that relate to this topic as well. So the purpose of this is to kind of address some frequently asked questions that people have about, what are the rights I have on my property for the recreational use? What's my extent of liability regulation to recreationalists? How do I protect myself? What about posting my land and trespass in general? How do I charge for recreational access and still provide, protect myself from liability? And the whole issue of timber trespass as well. So some of this stuff I'm just going to hit on real quick. And again, understand that there's a lot more detail in that extension bulletin that I just mentioned previously. So, liability itself is kind of a three-pronged sword here. It's like the perception is a lot of people feel that they're probably more liable than they are, because the reality is, again, in many cases they're not, but it also can be used as an excuse. So you don't want someone on your property, you say, well, I don't want to be liable, maybe not even understanding the extent of that liability. So I'm a professional forester. I am not a lawyer. So my disclaimer is here that this presentation is not intended to be a substitute for counsel from a lawyer or insurance professional. But a lot of this I put together over the years to kind of, in layman's terms, to address a lot of the questions that people have. But again, always rely upon, professional assistance and counsel when it's deemed necessary. So let's talk a little bit about general rules of liability, which basically descend from English law. We have private ownership in this land, property ownership. So how liable you are really depends on a visitor's status on your property. And the degree of liability is known as the duty of care. It depends upon the classification of that visitor. And there's three main visitor classifications. And you've heard some of these terms, I'm sure. A trespasser, okay? Very low duty of care owed. And then you have a licensee and an invitee. So let's just look briefly at what each of these mean in terms of how liable you are for different people depending upon their status. And this is going to get us into help you to better understand what the recreational statute is that we're going to be talking about and why it was put in place, because that's the real crux of what we're discussing here. So the status of a visitor for an invitee, this is typical business relationship where a person is invited to enter the property for the benefit of the owner. Typically money changes hands. It's a business relationship. You own a very high duty of care to that person to seek out, discover, correct, prevent dangerous conditions or activities, and to warn an invitee of those that cannot be corrected. So this is the highest duty of care owed. Below that is a licensee, where the owner provides permission, the owner's permission to be on the land to further their own purposes, with no particular benefit for the owner. All right, the owner has the duty to warn, not to correct hazards, and the owner has no duty to inspect the premises. So this might be a case where you invite someone to come over and hunt or to recreate or do something on your property. And then finally, we have the third classification, which is the trespasser, which you don't even know they're on the property half the time, and they enter or remain the property without your permission. And the law is clear that you owe little or no duty to seek out, discover, or correct unsafe conditions. So the question is, for people coming on your property, what are they? because the duty of care varies depending upon the visitor status. For that highest duty of care, which would be the invitee, failure to exercise ordinary or reasonable care, that's negligence. And then willful behavior or malicious behavior, that's intentionally trying to hurt somebody, okay, and to cause somebody harm. And the duty of care depends upon the status of the visitor. So the point here is not to get lost in the weeds on this. Is to understand the problem here is that the status of the visitor and the duty of care can change each situation, whether you invited someone on the property, whether they were trespassing, whether they paid you some money to recreate there, and the liability status can be very confused by the landowner. And the point is that creates little incentive for landowners to allow recreationalists to enter the property. Well, this was recognized as a problem many years ago, even in the 1950s. And this was when the Recreational Statute was created, all right? And it was originally based on a model act of 1965, Council of State Governments, the 1965 Model Act. And the point of this was that to encourage people to open their property for recreational use and to limit the liability of the landowner if there was no charge. And the intent of this was to encourage opening land to the public, because we have private property, but people are unsure about the liability status and all that kind of stuff. So this was to provide some protection for the landowner for recreationalists that came on the property when there was no charge. This Model Act was proposed again, updated a little bit in 1979. The point is that every state has adopted a recreational statute, but differences exist. So I'm talking about the Maryland Recreational Statute. It differs a little bit on how it's implemented in Pennsylvania, Virginia, West Virginia. So you need to be aware of that. But the intent is pretty clear. It's all based on this model language and this basic idea of opening up property for recreational use by limiting liability when no charge there's no charge. And that's what the Maryland Recreational Statute says right here. Encourage the owner of land to make the land, water, and airspace and the air above, for recreational educational purpose by limiting the landowner's liability toward people coming on the land for those purposes. So in its summary, what it does says that all visitors based on the statute, under the recreational statute, are basically considered trespassers. There's very little duty of care owed to these people, but it only applies if no fee is charged, and it covers the entire range of recreational educational activities. Now, a recent court case just came up, this Martinez versus Ross this spring, in Maryland court, circuit court. So, and that's what Paul is going to talk about, because it has some implications for public access and the recreational statute. So I'm going to let him, deal with that, since he is actually much more qualified to do so. So again, all kinds of recreation. You can see all these recreational activities. These are all covered under the recreational statute, and this is their listing. They've listed them here in the actually annotated code of Maryland. I'm not going to read all these, but you can see it's a very complete list. And when you go beyond that, it applies as well to off-road vehicles. There's a title that applies specifically to cutting firewood and coming under the recreational statute. And the point here is that even if that recreational activity is not specifically mentioned, the courts acknowledge them as recreational, because people, there's new sports created, like rock climbing, caving, GPS catching, and all these other kinds of things that may not be specifically, or mountain biking, that may not be specifically mentioned. And like I said, this includes educational activities as well. As an extension person who does a lot of workshops on private lands, this provides, the landowner some sense of, protection in terms of if there's injury or anything like that. And again, in the annotated code, educational purposes are spelled out quite completely. All kinds of activities. And again, I'm not going to read these. You can scan these later or look at them later, but pretty much includes anything, again, where you're not charging a fee. Now, the question comes up is, what is a charge? Okay, this was kind of a gray part of the recreational statute for many years. Now, a charge is a price or fee paid for services, entertainment, recreation, or products offered for sale on the land in return for the information, invitation, or permission to enter or go onto the land. But the annotated code was amended back in the earlier part of around early 2000s to kind of clear up this gray area for landowners, because a lot of people, they would have groups come on the property, and in return, perhaps they, fix some fences, or plant some trees, or do something. And what they reclassified to say the charge does not include the sharing of fish, game, or other products of recreational use. So someone hunts on your property, you don't charge a fee, but they give you some meat or fish, whatever, that's not considered a charge. And benefits to the land arising from recreational use. This means if whatever activity they're doing somehow increases the value of the property or something. It's a little nebulous, to be honest with you, but the last one's the most important. Contributions in kind or services to promote management or conservation of resources on the land. So this would be the case where people recreating on the land. In return, perhaps they're improving some roads, or doing some work that contributes to the conservation of the property. Fixing up some building or something like that, whatever. Those would be considered in-kind services. So that's a real positive, because it removes that gray area for landowners. And I know that a number of landowners were responsible actually for getting that change made, as well as a number of clubs. I know that the horse riding clubs were very involved in this when this legislation was being suggested. So also, the annotated code includes, the owner of land who directly or indirectly invites or permits without charge persons to use the property for any recreational or educational purpose. And again, it specifically has the provision about cutting firewood for personal use, okay, not for commercial use. Does not extend the assurance that promises are safe, confer upon the person the legal status of an invitee or licensee to whom a duty of care is owed. Basically, they're a trespasser, or assume a responsibility for or incur liability as a result of any injury to the person or property. So, this is a pretty good protection overall, and covers most of the types of activities that most people would be recreationalists, or people in firewood would be doing on private land, or would be asking a landowner to allow them to do. One thing you can't do is can't absolve yourself of all liability, and the statute makes that clear, that it doesn't limit in any way the liability which otherwise exists for willful or malicious failure to guard or warn against a dangerous condition, use, or structure. And again, I'm not a lawyer. Perhaps somebody would ask Paul this, but you have negligence, and then you have willful, malicious, damage or failure to guard. And the point is that these are fairly, difficult things to prove. The landowner would have to, or the recreationalist would have to prove you willfully or maliciously cause them harm, and be able to demonstrate that harm. And there's just not a lot of case law and stuff out there that I saw when I put this stuff together that really clarifies that, that makes that very common. So malicious is behavior purposely intended to cause harm. Traps, tripwires. This is why you want to have, if you have cable gates and stuff, you want to make them very visible. You want to eliminate hazards like that may be misinterpreted. And willful is behavior that falls between malicious and carelessness. So again, you never totally absolved from liability, but these are fairly, high standard to prove. So there are questions that come up with the recreational statute. Where does it apply? Well, typically in rural areas, but actually seeing also applies in a lot of urban areas. What about the need for public access in order to be considered under the recreational statute? Do you have to open your land to the public? You know, that's one thing that came into question with this recent case. What about liability of children? And again, I'll punt on these, and Paul will cover these when he comes in after me. So again, when it comes to lawsuits, you know, the recreationalist, you know, has to prove that the landowner knew of the condition, realized the possibility of the regulation to counter it, and the landowner willfully, maliciously failed to eliminate the hazard. In addition, the person who's injured must show proof of actual loss or damage. Again, these are, you know, fairly difficult things to prove legally, and maybe Paul can comment on that as well. Well, what this all really comes down to is that, you know, the way you reduce liability is to practice good risk management. You know, the way you avoid a car crash is, you know, you get your car checked occasionally, you know, ball tires and, you know, worn parts. Well, when it comes to your land as well, it's the same thing, and you avoid potential problems by practicing risk management. And just a few things listed here. You know, if you have hazards on your property, old buildings or something that are, you know, looking to collapse or something, or holes that somebody could fall into, you know, either post warning signs or fill them in. You know, do what makes common sense. Maybe talk with recreationalists before they come on the property. Provide a map that shows them things that they might need to know about that might be a concern. And as well as, you know, signing a liability release statement. Again, indicating that at least they have heard from you as the landowner and they absolve themselves. Again, when those things go to court, a lot of that is taken into account. But again, it demonstrates that at least you have made an active effort to reach out and clarify the risks that are out there. So moving on from that, the biggest thing here is that you really need to have insurance. And most people have farm insurance or homeowner insurance for that very reason, because anybody can sue you for any reason, anytime. And the reason you have insurance is if there was a judgment awarded by the court, the insurance would pay. But the top one is even more important, that if there's a legal defense, you know, if you have real or a frivolous suit, that your insurance would pay for that legal defense, which can be quite costly. So again, make sure your property is properly insured. If you have a farm, make sure all the parcels, if you have additional parcels, make sure they're all included in the insurance coverage that you have, because it's going to give you peace of mind. And also make sure you communicate with your insurance provider to know what activities are taking place on your land. If you have, you know, people hunting on the property, or, you know, people riding bikes or trail bikes or whatever, let them know it's taking place so that there's no surprises. And then if there is a problem with the activity, then you can work that out with them and make sure you're covered properly. And again, conventional farm policies don't cover fee hunting relationships or, you know, agritourism or on-farm enterprises. Those require special insurance policies. So again, communicate with your insurer, and it may or may not get a policy for that type of activity from your existing insurer. So I get a lot of calls from landowners who call me and say they expended a lot of effort. They have people trespassing on their land. You know, what do I do? And my retort typically is, you know, instead of, you know, focusing on how to keep people off the property, they should ask, who do I want on my property? Because, you know, it's difficult for people to find private land where they have permission to hunt or to recreate. Once they have that permission, they take it very seriously. And I think you may find that a lot of your problems with you know, trespassers will disappear, because they don't want other people coming on the property. It's just something to consider. I'm going to pop off a few things here just about trespass and property rights that you can look up, you know, more in the bulletin. But you know, for trespass, you know, if you want to post your property, you know, it should be posted conspicuously. And there is, you know, it's a misdemeanor for trespass. This is not, you know, a felony or anything like that. But when it comes to this, one of the good things that happened a number of years ago was that instead of using no posted signs or no trespassing signs, you can use blue paint marks like you see here. And Many states have this. Virginia, I think it's silver. Pennsylvania has passed this law apparently. I can't remember the color of the paint. But basically, a couple foot pieces of wide strips of paint. Make sure you can see one from the other. And it basically legally means the same as a no post or no trespassing sign. In our case, we use oil-based bright blue paint. And just one thing to note that in Maryland, if you do have a sign, it needs to really say no trespassing. Otherwise, the land won't be considered posted. The biggest thing about trespass with everything else is that you typically, a natural resources police or a police officer has to witness trespass. So that's very difficult to happen. And you don't want to be, arresting people and all this. This is a misdemeanor. But the biggest thing is that the landowner, if you want to press charges, let's say somebody is arrested for trespassing on your property, you have to testify in court in order for a successful conviction. And that's many times where people back out. And for many people, you really want to work with your neighbors before going to the extent of going to court, because you can create a lot of hard feelings with neighbors, and especially if you're absentee landowner off the property, the last thing you want to do is create bad relationships with your neighbors. You're not there on the property. When you're not there, all kinds of things can happen. It's best to work these things out. One thing I would say just briefly about off-road vehicles, because ORVs could be a big problem for people. If a person is approached by an officer about that, the law clearly specifies that person has to have in his possession the written permission on their person. And if they don't have it, they can be given a citation right there on the spot by a natural resource police or a sheriff. But that's different than hunting, because hunting requires that you have written permission, but it doesn't require that it be on the person. So what happens when talking with natural resource police is that they'll ask the hunter, do you have permission to hunt the property? They'll say, yeah, I do. Oh, I don't have it on me. So then they have to go out to the car and try and contact the landowner. And, it just wastes a lot of time. So when you're hunting, make sure you have that written permission on your person, if at all possible, so you don't waste the time of police. Just suggestions on trespass. Work with your neighbors, mark your boundaries. Lease with a group. Many times, if you're not going to be on the property, and it's best to try and work these things out with recreationalists rather than go into a legal trespass situation. Natural Resource Police, when I put together this publication, mentioned that many times. So you want to create good relationships with your neighbors, and you don't want to put yourself at odds with others when all kinds of bad things can happen. A couple things about just interest about the waterways and recreational use that you may or may not know. When it comes to tidal waters, the waters up to the mean high tide, in other words, all that land underneath that body of water, a tidal body, and up to mean high tide are owned by the state. So, you can't cross private land to get there. But the point is, when you're going on the ocean, those tidal waters, you can actually put your boat, as long as it's below the mean tide level, and still be on public property. Because it's owned by the state. It can be used by recreationalists. Of course, if you go out of high tide, I guess you're stuck. That contrasts with non-tidal lands, streams and creeks, where the land beneath the water is privately owned, So the public has the right to use the land, but not the land under the waters. So what this means is, a recreationalist, you can boat, fish, and ski, but the land on the edge is actually private property, which you're supposed to have permission to use. And actually, by law, I guess you're not supposed to anchor or touch the bottom, because it's actually privately owned property. Now, of course, this is just helping you understand what the law says. I mean, just so you know how that works. What that would mean in practical terms would just depend on the situation. One thing that you should be aware of is a lot of people hunting, people buying land. They want to set up a shooting range, or they're out hunting. Make sure you know where your bullets are going. Reckless endangerment is an issue, and there are people that are cited for this. This is where, you've heard the places where somebody was in the house and a bullet came through the wall or the window. It was discharged by a firearm, maybe somebody hunting in the woods, maybe somebody was shooting targets. But you don't want to set up a situation where you're reckless, as it's defined here, where there's creates a substantial risk of death or serious physical injury. So again, just know where you're shooting, and as properties get smaller and smaller, this is why just know where you're shooting. That's all I'll say about that. Finally, timber trespass. Most states have a timber trespass law, and they're very similar in many cases, actually. If someone cuts your trees without your permission for any reason, they are liable up to triple the value of the timber cut that can be recovered. The challenge with this is that, let's say that happens, then it's incumbent upon you to hire a professional forester to measure the stumps for them to determine what species of tree, how much timber was removed, unless it could be actually found, measured, which is usually not the case. This puts a lot of expense on you with lawyers and expert witnesses. In most cases, it's best to try and work things out. In many cases, they're mistakes. If it's pure theft, things that can help, again, are to mark your boundaries, which regulate gate access roads, communicate with your neighbors. And if you are having a timber harvest, make sure you have a professional forester involved. But again, this is a remedy that's available to landowners if it's definitely an outright case of theft and has been used in the courts. It just requires some cost on your part. You have to determine if the amount of it's going to cost to hire experts and go to court is worth it, based on the amount of timber that was actually taken. Finally, just real quickly, I would just say that we've talked about the recreational statute, where you don't charge a fee. But what happens if you want to charge a fee? And I personally have land in West Virginia. We've had a hunting lease for the last 25 years with different hunting groups. And some basic survey I did in Maryland a number of years ago, it's hard to get this information. For deer and turkey, $8 to $20 an acre for hunting rights with a hunting club is not out of the ballpark at all. You get on the Eastern Shore with goose blinds and other types of things, the numbers can go way up high. So this is a way to get some income, but the thing is, and there are benefits, in terms of having people on the property, reducing vandalism, improving wildlife management. Again, of course, improving profitability, at the very least to pay the taxes, which is how we do it. But there is some trade-offs. It's going to take some time and effort on your part in working with hunters on your property. But the point is, it can work out pretty well. And in the guide, in the bulletin, there's examples of written leases. Make sure you have a written lease. And one thing, most hunt clubs are not incorporated. So whoever the people are that are going to be hunting on the property, make sure they all sign the lease. Because you wouldn't want to have someone who speaks for a club, they sign the lease, and then something happens, and they say, well, I didn't know about that, the other people. So you get everybody to get it notarized by all people that are going to be on the lease. And of course, you have to have specific lease liability fee hunting coverage, which is available through a number of different groups, the Maryland Forest Association, Forest Landowners. There's a number of them out there. But there are a couple of them are listed here, and you may be able to get it through your existing provider. Just look at the costs involved. Many cases, depending on how many landowners there are, the cost may be higher. It just depends on how the insurance is structured. So that's what I have. With that, I know I bounced through a lot of stuff, but I would encourage you to look through the guide, that bulletin, and you can get some more information. So with that, I'm going to stop sharing and hand this over to Andrew, who will get Paul on board.
Okay, Paul, you can go ahead and start sharing your screen.
Okay, perfect. So Jonathan's kind of done a good job going over, and I'll go back a slide, going over the rec use statute and a lot of how it works. I'm going to talk about court decisions that have happened. We've really had only two that have really impacted the recreational use statute in the state. And then I'm going to throw in a little bit about what you should be doing if you got people coming on to sort of limit liability associated with COVID-19 as well. And that'll be the last little bit about PowerPoint. I've got this in here. I'm assuming y'all are going to get a copy of the slides at the end. We have the Ag Law Education Initiative that I'm a part of. Our website is umaglaw.org. Get that information there. Oh, and I forgot my general disclaimer. None of this, much like Jonathan had his disclaimer that he's not an attorney, I'm an attorney, but I'm not allowed to give you any legal advice in my job with the university. My job is only to educate, not to be your personal attorney. So if you need that, I can get you in touch with an attorney and they can work with you on some of the more specific issues you may have to your operation. So like I said, Jonathan's really gone over the rec use statute well and some of the basic stuffs. We're going to really talk about some of the court decisions and then go into a little bit on what you need to be doing to sort of limit liability, especially if you have people coming on for agritourism, recreational use purposes, some of the things you should be considering doing on the farm. So Jonathan kind of hit upon this case in his presentation. He kind of skirted it, but we're going to talk a little bit. It's Martinez versus Ross. It just happened this year. So we have a landowner who opens his property up to a large social gathering. It was basically he invited people over from his church to come out and ride on an ATV course he had set up on the property. One of the attendees was riding an ATV that was provided by the landowner. He was severely injured during the gathering and is now suing the landowner in this case. Go quickly to the sort of facts that we need to pay attention to. The property has a fence all around it. It has a gate to get into it. It's locked at all times. There are signs posted all around the property that say either no trespassing or keep out. He had a lot of signs on the property. So the question really is can this injured guest sue the host of the party? In most cases, if we look at it, the property's open, they come on the property, we would think the recreational use statute should apply in this case. And the district court actually agrees with this thought in this. The landowner argues this. They say we open the property up, we should be allowed to utilize the recreational use statute. Well, some issues happen with this, and I'll go make sure I have the chat open in case I see some questions as I go along. So the Maryland Court of Appeals actually, or Maryland Court of Special Appeals, I clicked too far, actually doesn't agree with this. The court rules that the landowner needs to actually open the property up more than to a limited class of users. Here we only have people going to the party. Everyone else is told to stay off the property based off the signage, the fence, the locks on the gates. So what happens if you're that landowner, you want to keep the property open, or you want to keep the property closed, but you still want to have people come on to utilize it? We're going to talk about that here in the next slides, but you know, the court kind of points out you don't have to open the property up all the time. You could make these limited exceptions where you let somebody come on to use the property to access a public trail on horseback. You could let people cross in other ways. They used a example of people using it in the winter to cross country ski across and get to, you know, another trail. So in the decision, we really don't get a lot of guidance as to what this all means. And let me go to the next set of slides. There's this other case that involves a Marriott hotel that's now not a Marriott anymore. It's actually really close to where I currently live. And in this case, we have this guest. This is the only other decision that involves a recreational use statute. We have this party guest who, or not a party guest, he's a guest at the hotel. He goes out and jogs on a fitness trail that's on the property. It's cold, it's icy. He hits black ice and he slips. Court rules the recreational use statute applies in that case. But why does it apply in this case but not in Martinez? Well, the biggest issue here is we have this trail open to public use. Anyone can use it. There's no trespassing signs. There's no nothing. You can come on even if you don't stay at the hotel and utilize this trail to go run. So it's open. In Martinez, if I go to the next slide, we have a property that is clearly fenced off. It has signs. The only people we're letting on are these social guests that are coming to a property. So the recreational use statute doesn't apply. At this point, we really don't know any more than this. We know that you have to open the property up some for the recreational use statute to apply, but we don't know exactly how much you need to open it up. The court said you can let people intermittently come across it. You don't always have to make it open. It can, be some sort of limited access in some ways, but you still have to open it up to more than just people coming on the property for a party. So yeah, it's not exactly the clearest, but it's kind of giving us a little more guidance as to what we should be expecting in some of these cases. So what are the takeaways? Like I said, you're going to have to open it up some. How much? We really don't know at this point. All we really know at this point is it's got to be somewhere between a public jogging trail associated with a hotel and somewhere between shutting your property down and only letting people going to a party at it on. And as the court looked at this, they looked at it and said, this is actually the majority view that most states, like Jonathan talked about, this was based, most of these recreational use statutes are based around model language that was developed in the 1960s and most states adopted. Most states that have taken this, have interpreted this law, have taken this approach that you actually do have to open it up in some way to gain the protections of the law. You just can't limit it to whoever you want to. So we used a hunting club example. That may actually that wouldn't apply for the recreational use statute because you're collecting money in that case. So that's not a good example. But in other cases, if you let somebody come on just to hunt once a year and you don't collect any money from it, that may work. You may be opening it up enough. It may be slightly more than here. If you've got no trespassing signs, we might be getting closer to the Martinez case to where we don't know. The other thing I need to point out about Martinez is it may still be appealed to the Court of Appeals, and we don't know what the final outcome there would be if the Court of Appeals would even hear it. So this is sort of tracking with what the majority view has taken on these laws, but we still don't know what some of this would be. If you're opening the property up for educational purposes, which is allowed under the recreational use statute, that may be safer in those cases because you are opening it up probably to more people. You may be letting school groups come on, utilize it. That may be enough. We just don't know at this point. So I'll move on with my little bit of remaining time and talk about COVID-19 issues. So what should you be doing? Well, the first thing I would tell you is take into consideration what activities you have going on the property. What exactly do you have people doing either recreationally or as part of agritourism on the property? And that's going to help guide a lot of what you end up doing. Oh, went too far. So if it's just hiking, fishing, hunting, some sort of recreational use where they're outside, there's not that many people coming on the property, you probably don't have to do a lot other than remind people they need to probably wear a mask if they can't socially distance, and at least remind them to bring hand sanitizer or something to wash their hands periodically, just to make sure that people are at least, reminded of what the typical health guidelines are right now. Now, if we get into the more intensive uses, we're bringing, agritourism onto the property. We've got educational groups coming on the property. We've got other stuff coming on the property where people may be more congested together, and it may be more than just one or two people out on this whole property, but they may be in closer confines together. That's when we may need to start reminding people that they need to stand 6 feet apart. They need to be wearing a mask. They need to be doing other stuff that can potentially prevent the spread of the virus. The other thing is we may have to start thinking about, do we need to provide hand sanitizing stations? Is that available? The one thing I will say on this is Maryland Department of Agriculture. I looked on DNR's website as well, didn't see as much related to COVID, at least from what landowners should be doing, but Maryland Department of Agriculture has put out some guidance for agritourism operations, farm markets, a lot of stuff. So if you're in this category where you've got a lot more people coming on the property, you might look at that stuff as well to start going through some of their checklists and information like that, just so you're understanding what you need to be doing. And from the looks of stuff that I've seen during this time period, they are updating that as the situation changes to provide more guidance at times. The other thing to point out is look at what the CDC is doing, telling you to do, look at what the state health department is doing. Like I said, MDA has a COVID-19 resources page. You can find it right on their front page. And they've got a lot of stuff on there that will help you, if you're one of these operations, to better understand what you should be doing in this situation, and will hopefully keep it updated to where you know what you should be doing depending on how the situation changes. The other thing to point out with all this is lawsuits related to this, they're going to be a simple negligence case. The hardest part in all of this is going to be able to prove you are at fault. It's really going to be hard to prove, potentially that you are the cause of some sort of widespread cluster that led to more cases. The thing that will get you in the most trouble, and looking at this, we had done some research when it came to biosecurity related to animal operations a while ago during avian influenza, and a lot of the principles apply to this as well, oddly. If you're not taking safety precautions, or at least going through the steps to make sure you're trying to put precautions in place to limit the spread of a disease, that's when you get in trouble. That's almost always when courts have found fault in some way in some of these disease outbreak cases. Now, again, this is related a lot to animals, but a lot of the principles that courts have used in those cases would probably apply in this case and in cases like this, and it might create a harder case for you to win. So let's talk about the wrap up. So based on the cases, you're going to have to allow the public on to gain the protections, but we don't know to what level yet. That's going to take time. It takes court cases to kind of figure this out. The General Assembly may get involved, but that may create definite lines that not everyone will hit in their operation. That may make it to where you thought you had the protections, but now you don't. And if a court had decided it, maybe you would have had the protections. So we'll have to wait and see on a lot of this how it's going to play out, and if there are other cases in between. I believe there's been about 10 years between recreational use cases in the state. It may be a little bit more than that. So we may be waiting a while to get more clear guidance on this. The best advice is just do what Jonathan has talked about in his presentation, is take that into consideration. Work with neighbors, make sure people are aware of bad spots on the property they shouldn't be going. Try to keep them safe, reasonably. Willful, I can't remember the standard, willful and malicious is a very hard standard for you to end up meeting, but you can meet it if you don't actually take into consideration things that you create on the property that may create damage, like Jonathan was talking about, fences and other things that could end up hurting someone if they're not aware of them, need to be pointed out in some ways. With COVID-19, think about what you're using the property for. Whatever that use is, look to see if Maryland Department of Ag has guidance on it. Look to see if CDC has guidelines, the state health department has guidelines. Follow those guidelines, make sure you're taking that into consideration. they're going to be hard to prove in potential lawsuits, but doing nothing is probably the worst thing you could be doing to help limit your liability and at least provide a defense if for some reason something did happen. And Jonathan's already talked about my blog that we do through the department. You can find that at agris.umd.edu. And if you like them, I've been doing more interviews on my podcast, but typically I try to talk about some of the posts on there and give you more of a reading of it and talk about some of the details that didn't work and what I actually posted. And that's at marylandagpodcast.org. And are there any questions? And that's my contact info.
Okay, thanks, Paul. We do have a number of questions that have come up, so let me go through those. And Jonathan, you may be able to jump in here too. Okay. One of the comments was that was about the blue paint law. The question was, so blue paint does not hold up in court as significant posting for no trespassing? Or is it?
No.
Okay, go ahead.
No, basically it's the same thing as posting a no trespassing sign. And the reason these paint laws have been passed is because, you know, people come along, it's a big expense to landowner to put up no trespassing signs, and then people rip them down and everything. So, you know, blue paint is a relatively easy way for a landowner to post their land for those that want to post it. So yeah, in court, it's the same thing as saying no trespassing. It's the same thing as a sign. That's my understanding of it.
Yeah, the photo you had, one of the photos showed a no trespassing sign and the blue paint.
Oh, yeah.
Do you need? Well,
No.
I'm just curious about this. Do you need to have no trespassing signs every X number of yards, as well as the blue paint, which needs to be visible from place to place?
No, I just had that picture because it showed both types of posting on one tree. But yeah, I mean, the way it's put is, you know, you should be able to see, you know, one sign to the other, you know, so that if somebody's entering the property, they can see a blue paint mark, you know, to either side. So what distance that might be could vary depending upon the terrain and other things. But you'll see this if you drive around. You'll see, you know, blue paint on fence posts and on trees, and, you know, maybe every 50 feet or something. It just depends on that, the distance.
And I believe you'd want to make the paint high enough so that it's visible in snowy conditions as well.
Well, it's when you look at the regulation, it specifically states, you know, how it should be. It should be like, I think they're 4 inches by I can't remember. Anyway, it's in the guide. Vertical paint marks 2 inches wide and 8 inches long, centered 3 to 6 feet from the ground or the water surface, using an oil-based bright blue paint. So.
Okay. Paul, we have a compliment on your visuals during your presentation, but then also wants to share the opinion that the recreational statute seems rather vague, and you touched on that a little bit because there are very few cases. Was the case with the hotel something that would be considered in the suburbs, or I guess they're looking for something with people who are dealing with property problems in a suburb rather than in an urban environment?
But no, that hotel case would be in the suburbs. That hotel's right outside of College Park. The one in question, that's in Maryland's the only case involved in the suburbs so far that I know of. That's reported, at least.
And I think this applies to public lands as well, doesn't it? To some of this as well.
Yeah, and in other states, there's usually court decisions. Most of the recreational use statute court decisions almost always involve either federal property that's open or state property that's open. Because
I know that with this charge thing, that was one of the reasons that interest in that was by state parks and stuff, in terms of how liable they were for people if they charged an entrance fee and all this other stuff. So that was, I remember, one of the things that came up in that.
You know, if I remember, as long as they just put a donation box out, it's not collecting a fee.
Okay.
You can give as much or as little as you prefer to use the property, but I forget, I can't remember the language in the statute, but it would meet one of the qualifications to still fall under the statute.
I'll just address this one thing on the chat box. It says 90 days in prison or $500 is a lot for accidentally stepping over a property boundary. And person agrees with maintaining good relationships. And again, I you know, that's the maximum amount. I mean, my understanding is that that's not going to be typically what's charged in these cases. That's just the maximum.
Okay, right now we have just one more question asking if you open it up for hunting only to specific persons for no fee, then would it be limited? With that decision, it seems that the recreational use statute could be argued as not applying. Sounds like the statute needs to be amended.
Go ahead, Paul, once you.
Yeah, it may need to be. I mean, yeah, you have a valid point there. It may not if it's just one person. We just don't know. I mean, in some of the examples the court used, they used the example, you could let one person ride horses across your property to get to a trail and it still would be open, but I don't know on hunting or anything like that at this point. So yeah, it may need to be amended to allow for some of that.
Okay, we have covered all of the questions, I believe, and we are just about to the top of the hour. So I would like to thank Jonathan and Paul for coming. And we have other webinars in the pipeline. We don't have one scheduled at the moment, but we'll let you know two things. Number one, we will let you know when the recording is available. We had a couple of questions about that, and yes, we will make it available. If you've registered for the webinar, I will send out an email to you when the recording is available and how to find it. And we'll also let you know if you've registered when we have other webinars in the Wildlands series scheduled. And we're just about done for the day, so I think I will go ahead and thank everyone for joining us and enjoy the rest of your day. Thank you.
Take care.
Thank you.
Take care.